realize it makes a big deal. Another category of damage is you get what's called emotional distress. That's where typically the plaintiff has a psychologist or a psychiatrist, and they come out and they testify and they say, this person is so psychologically traumatized because of the actions that took place here, they will never be the same. There is no way that you can possibly award them all the damages they're going to suffer, because basically they never will be the same. But your obligation is to do the best you can. So what can you do? How much does it cost to go to the movie theaters? $10, $15 a person. Let's take this person here who's been sexually harassed. She's 30 years of age. Her life expectancy is another 45 years. Multiply 45 years times her income, which is $30,000 a year, and you come up with some astronomical number. Will the jury award that? Typically not. But when the jury goes back in the deliberation room, they've got anywhere between $0 and several millions of dollars just for this category of damages. And if they're angry, and they sometimes get very angry about these situations, emotional distress can be a huge category of damages. Also, what you get in these cases are what are called loss of wages. Case goes something like this. I'm the plaintiff's attorney. Ladies and gentlemen of the jury, in this particular case, my client was sexually harassed to the point where she had to quit working for this company, where she was fired because she reported this sexual harassment. She makes $30,000 a year. She's got a work expectancy of another 30 years. Multiply 30 times 30. You get some astronomical number out there, so many hundreds of thousands of dollars or over $1 million. And they put that number up the board. Will the jury award it? Typically not. But they can award anywhere between a $0 and up to several millions of dollars for lost wages at their discretion, depending upon how mad they get back in the jury deliberation room. And they can get very angry. The trick of this game is, quite frankly, is avoidance of liability, because once you get sued, you've lost. And so basically what FMC does, it has written policies and procedures. It tells you what you can and cannot do. It gives you some idea that if you believe you've been sexually harassed, these are what your obligations are, and you need to report it. In this case, you've got Chris, who's your designatee, to go through and contact regarding such conduct. You've got written policies and procedures as well. And if you don't do that, quite frankly, and you've been sexually harassed, there's an argument that basically you may not be able to go through and file a complete claim, because there's cases that have come down in the last couple of years with the U.S. Supreme Court, called Farragar and Boca Raton cases, that basically go through and say, if your employer has a written policy, and if you don't report the sexual harassment, then maybe you might be precluded from bringing a claim. Some of the laws are changing. There's some conflicts back and forth out there. Also, what you get in these kind of cases, besides loss of wages, is attorney's fees. Attorney's fees in these cases can be $100,000, $200,000, $300,000. So if you are going through and you engage in sexual harassment, you have to pay not only your attorney's fees, you might have to pay the other side's attorney's fees. So there's all kind of reasons economically to be very careful about this. And I can tell you, having done this for 20 years or so, it's not a real bonding situation when you go home to your spouse and tell them you might lose the house because you've just been sued for sexual harassment. It doesn't exactly build a marital relationship up tremendously in this regard. And I can't tell you how many times I'm brought in to go through and consult with and talk with the family members about this, where they say, hey, explain to me exactly what happened here. Why is it my husband got sued for sexual harassment? What's really going on here? Used to be, a lot of people, when I first started doing this several years ago or so, people talked about, why is there sexual harassment in this world? And people would say, well, that's just these old gentlemen of the old world. They're misunderstood. They open up doors for ladies and they're, they just don't understand what's going on. Well, those guys are all dead and business is booming. Okay? That's not what's going on here. Look at what the amount is of sexual harassment claims that occur. Many people believe there's different theories about sexual harassment. One theory is, and let me refresh your recollection a little bit. You guys remember when Clarence Thomas went for the U.S. Supreme Court, and we had Anita Hill who came over and said, hey, Clarence, you shouldn't get the U.S. Supreme Court position because you sexually harassed me previously. That's when sexual harassment, in my view, really started coming to the forefront of what was going on out there. And in that case, you have the same thing that you have in all sexual harassment cases, in my opinion. You have two people who have stories 180 degrees apart who are fairly credible. So most sexual harassment cases are. I've never had anybody come and say, hey, I admit it, I sexually harassed this person. It doesn't happen that way. People's perceptions are significantly different. Surveys and studies that they've done, if you go back and look, they asked males what their perception was of who was telling the truth between Clarence and Anita. They asked females. The study showed most males thought Clarence was telling the truth. Most females thought Anita was telling the truth. Surveys that they've done since then basically say that most males perceive that most females think that everything is sexual harassment. Most females, according to these surveys, think that most males don't think that anything is sexual harassment. There's a huge difference of opinion and perception about this topic. And many times it's my perception, that's why I'm so busy in this area. You have to understand the differences here. FMC has a zero tolerance level for sexual harassment, which means they don't allow anything to happen in the workplace. It's prohibited. Some people say as well, we can't joke around or we can't do this, we can't even be sociable out here. And the problem is this about sexual harassment. You cannot have a written policy that says when you can and when you cannot make jokes of a type of a nature. I can go over to this group of people over here, these folks, and I can say, hey, in this particular situation, let me tell you this great joke. They might think it's hilarious. I go over and go tell this other group over here, they might smack me. I can't put that in writing. There's no way that I can put down when it's acceptable and when it's not, and you'll never know. The biggest offense to sexual harassment is called consent. And basically, if somebody consents to sexual harassment, then technically it's not sexual harassment. The trouble is you will never know. And I've had this happen in several cases. I go up to this group of people here, let's assume I'm their supervisor, and say, hey, I got this great dirty joke, let me tell you about this, okay? They say, fine, sure, tell us about it. So I tell it to them. 2 months later, they're all laid off, okay? One of the three over here basically says, you know what, when I said to Jeff it was okay to do that, I wasn't telling the truth. I just agreed to it so I wouldn't be ostracized or kicked out. And so therefore I was pressured to say yes. So even if somebody tells you it's okay, it's not okay, because you will never know about the issue of consent. You want to be careful about these things because different people's perceptions are significantly different. Let me give you a couple examples here. In this outline, I'm going to let you read through this, give you some of that information. And because the time frame's over here, I'm not going to spend much time going through some of these things, but let me give you a couple hypotheticals here. There are, let's take this example. And by the way, I don't ever use anybody out of the audience for these seminars because there was a firm that did this 3 years ago and they got sued for sexual harassment, so I don't use anybody out of the audience doing anything like that, okay? But we got a situation here. Let's assume I'm at my desk, my secretary comes walking through the door. She comes in there and she's wiggling her, I think she's wiggling her rear end, and I say, hey, your rear sure looks nice today. She says, kiss off, I quit, goodbye. I say, fine, accept your resignation, but if she's walking out the door, but I say, also, I still like the way your rear looks. Now this is, you have to get involved in this part of it, okay, by showing of hands. How many believe that last statement that I said to her about her rear sexual harassment? Everybody raise your hand who thinks it was? Everybody raise your hand who thinks it's not? Okay, it's not. Why not? Anybody know? No longer employed. So hey, it's freebies on non-employees. Is that what that means? Not really so, okay? Because there's certain things that they still can come back and sue you for regarding other things, but technically, the way the laws were written originally was sexual harassment applied between employees and employers and landlord and tenants. In California now, that has been broadened significantly, where it applies to other relationships. But the old rules used to be that would not be sexual harassment. The first comment I made to her when she walked through the door about her rear, was that sexual harassment? Everybody raise your hand if you think so. Everybody thinks no, raise your hand. It was. That was clearly sexual harassment. In California, basically there's really, in my view, 3 different types of sexual harassment. One type of sexual harassment is what is referred to as hostile work environment. Okay? Let me give you some, anybody have an example of what a hostile work environment sexual harassment would be? What do you think? Don't attack me all at once here. Let me give you some examples. Telling jokes in the workplace. Basically the emails or faxes that you see passing around all over the office. If I really want to get something out quick in my office, I don't tell people stuff. I make them sneak it like it's a rumor and it goes everywhere out there, okay? What are some other examples of sexual harassment? The best examples you see out there are basically these posters that you used to see, of course, in the garages where these guys have got naked women and all that stuff on the calendars out there. Okay? The law basically says this, that an employer has an obligation to have a hostile-free working environment wherever the person is working within the course and scope of their employment. They should have to put up with this garbage. And a lot of people say, you know, this is a bunch of garbage. This whole thing about sexual harassment is a waste. Well, I do mostly defense, almost 95%. I'm here to tell you, not all of these cases are frivolous. There are some tremendous abuses that are happening out there. These laws didn't come about because basically it was just a politically right thing to do. They had people being abused out there. I've taken a couple cases this year. I mean, quite frankly, we see some of the cases that are coming down the pike out there. There's some pretty tough stuff that's going on out there, besides physical assault, batteries, everything else that you can imagine that's going on out there. So my suggestion would be is that when you hear people, and usually I hear it quite frankly from people who've been around quite a while, they say, oh, that's that sexual harassment garbage. People should go through and be able to stop that whenever they want to. It should not be a big deal. Well, I got to tell you here, again, looking at these cases, a lot of these cases I've defended, I'd much rather been on the plaintiff's side. Because again, when you see some of the assaults, some of the batteries that's taking place out there, some of the misunderstandings that people have from an employer level is pretty shocking stuff. The whole point of these programs is for FMC to say, hey, We won't allow it to happen. If it happens, tell us about it and we'll jump on it immediately, because that's what we have an obligation to do. This videotape's admissible for FMC. If they ever get sued for sexual harassment, to show they provided training and education. You've got written policies and procedures that FMC provides. You've got things posted up here in the common local areas of the walls that tells you about what you can do regarding sexual harassment. And basically FMC is saying, if it's there, tell us about it. We'll jump on it in a heartbeat. And that's really what you want to be aware of, quite frankly, when you're going through and working in this environment. Different types of sexual harassment. One's called quid pro quo. That's where a supervisor sexually harasses. I'm looking on page 3 of the outline. One type is called quid pro quo. That's where a supervisor sexually harasses a subordinate. Okay? Another type of sexual harassment is called hostile work environment, which is what we just talked about before with the joke telling, all of that. I think there's kind of like a third category, and it's sort of my quasi-category called retaliation. Somebody comes up and complains to a supervisor and says, hey, you know, I've been sexually harassed here. Supervisor says, that's fine, we're transferring you out to the needles department. You know, that's pretty cruel and unusual punishment. So that was a joke, guys. Working. Anyway, so if you go through and you retaliate against somebody who's sexually harassed or complaining about sexual harassment, that's grounds to be sued as well. An employer, as is the case with FMC, will affirmatively go out there and investigate these matters and check into them. And they will research these things and look at them as confidentially as they reasonably can. And that's the promise they're making to you as employees about doing those type of situations out there. And it applies to males and females alike. That also applies to laws as of 3 years ago from the U.S. Supreme Court applies to same sex. So again, if that's taking place out there, FMC wants to know about it, make sure it's not occurring in the workplace out there. You skip ahead a few pages over here. Let me give you a few examples here which are also difficult. In the workplace, most people, they talk about relationships and how they evolve, quite frankly. One of the most common areas that people's relationships evolve are in school. One of the most common other areas that they evolve is in the workplace. And what happens is, basically, many people are dating people they're working with out there. Okay? That's their right, that's their choice to do that, as long as they don't bring it into the workplace. The minute they bring it into the workplace, then it becomes the employer's business. They have a right to go through and address those situations as they're taking place out there. And so you want to be kind of careful about that. So FMC is not saying to you, hey, you know, don't date co-employees, don't do anything like that. But basically, keep in mind, in California, you got a divorce rate now of 54%. You got a separation rate of people who are dating of about 190%. So it's kind of tough out there. So again, those are situations that can arise to create problems for the employer. And I've been through this so many times before. Everybody who has, especially when it's a supervisor and a subordinate dating one another, they always say, we can make it work. We know what's going on. We can handle this situation. And rarely do they. Okay? The perceptions are usually by the coworkers, hey, there's favoritism going on with that person out there. Or, quite frankly, they have a falling out and they start getting bitter towards one another. And it usually gets brought into the workplace. And so FMC, again, has to address those situations as best they can when those concerns arise in that situation out there. A couple other examples here about sexual harassment. Let me give you a comment about kind of whether or not you believe sexual harassment has occurred in the workplace. Let's take an example. I had this case several years ago where this fellow was the owner of a golf club, a golf country club. And basically he had 3 ladies went through and sued him for sexual harassment. What he said, and I was defending him in the lawsuit, is hey, quite frankly, I'm intoxicated every time anything is happening out here. I really have no recollection of any of this. First of all, you hear that and go, yeah, that sounds like a common story you'd hear from everybody. But what was interesting in this case was all 3 of these ladies agreed with him. They said, that's true. He has no recollection. He has no idea what he's doing when he's intoxicated. We agree with that. Issue. Is that a defense to sexual harassment? Everybody thinks yes. Raise your hand. Who thinks no? Raise your hand. The answer is no. Doesn't matter what his intent is. It's basically called an objective standard. When people are looking to try and determine if sexual harassment occurred, it doesn't matter what he thought. It matters what, let's assume there's a little birdie up in the corner watching, and what does that bird think's going on? Somebody objective looking at this situation. Because otherwise what would happen is everybody would say, hey, I was just kidding, I didn't mean it, I was drunk, and nobody would ever have a claim for sexual harassment. The law says it doesn't matter so much what your intent is. It doesn't matter that it's a joke. It matters what an objective person seeing what was going on here would perceive. What I do, I've been writing, just about to complete a book that I've been working on for quite some period of time about how to avoid liability. And one thing I talk about, quite frankly, in going through and evaluating those situations over there, is talking about what I like to refer to as kind of the blue-haired lady doctrine. And my own little biased opinion on these things about sexual harassment and also litigation is, for the most part, and there's always exceptions out there, For the most part, our jury system works pretty well. And that's because basically people are out there to go through and choose and select, and they make a decision based on what they perceive to be right or wrong. About 20 to 30% of most jury panels are made up of retired people, blue-haired ladies. When you're out there thinking about what's going on in the workplace, and you're engaging in any type of a conduct, imagine one of those blue-haired ladies is looking over your shoulder. Maybe it's your mother, maybe it's your grandmother. And basically ask yourself, would they object to what I'm doing? Chances are, if they would, they're going to be sitting in that jury panel out there deciding if you get to keep your house or not. And think about that. You don't have to go through and know all these laws. California's got almost more laws in this one state than almost all the other states put together. I think I'm pretty savvy on this stuff. You don't have to know all these laws. In my view, you have to kind of keep in mind the blue-haired lady doctrine, keep in mind who that person is looking over your shoulder, what conduct you're engaging in. Also, just use common sense. I kind of refer to it as using the golden rule of employment, that basically you treat other employees like you want to be treated. And the minute you start crossing the line, usually you get sued. And I got to tell you, until you've been sued, you will never have any idea what it's like. The lawsuit will last for an average of anywhere from 18 months to 2 years. For that time period, you'll be wondering if you're losing your house. For that time period, your relationship with whoever your significant other is not going to be really booming, quite frankly, because they're not going to be too happy about what's happened out there. And that's assuming, of course, that you're the accused harasser in that situation. And the only way, again, for you to know about this is really to get sued. And by then, your life will never be the same. Everybody I've ever defended's life has always changed dramatically from litigation because it's such a traumatic event. Whether they actually did it or not, quite frankly, their lives will never be the same. The trick is never to be put in that position, because once you're there, it's too late. You've just given up about 2 years of your life. It's a high price to pay. And for those people who, and let's face it, the percentages about complaints about sexual harassment are going up astronomically without even lawsuits being filed. And once you're accused of sexual harassment, and usually it's not very confidential, usually it gets around all over the place. And once you're marked with that, it is very difficult for you to get another job anywhere else. Likewise, quite frankly, for the person who's making the accusation of sexual harassment, quite frankly, if you're branded as somebody who goes around complaining about sexual harassment, they're marked, because it's very difficult for those people to get a job elsewhere. That's why these cases are so emotional, because basically they're coming together to fight, and whoever wins between the two is really going to be winning a lot more than money. What they're going to be winning is their reputation. One is either going to be branded as somebody who makes false claims regarding sexual harassment, or one's going to be branded as somebody who's a sexual harasser. Either way, it's a terrible brand to have when you're in the work world. And let's face it, this is not that big of a work community out here. Everybody knows about these things. People typically get on the phone and call and ask, saying, hey, what do you know about this person? Doesn't mean they have a right to do that, but that's what really happens in the real world out there. So the suggestion is, avoid that at this stage. Watch your liability, watch your exposure. If you can, on page 4, bottom of the page, it gives definitions all the way to page 5 of what is and is not sexual harassment. That's defined by the Equal Employment Opportunities Commission. If you have been sexually harassed, you got 1 year to go through and file a claim with what is referred to as the Department of Fair Employment and Housing in the state of California. You've also got within 1 year to file a lawsuit if you want to go through and file with Superior Court. So basically those are remedies that are available to you as employees if you think you've been treated improperly or unfairly. And basically FMC is going through and making it known to their employees about their rights in that regard. On top of that, basically, if you look at the relationships over here, it talks about unwelcome conduct. Let's take this situation. Let me give you a little hypothetical here as well. Let's assume that we got two people who are dating one another. And one of the persons who is dating basically feels like this person's crossing the line. Even though we're dating, now this guy wants to do more. Is that sexual harassment? It is. Again, what happens is unwelcome conduct can occur even between two consenting adults who have a relationship with one another. Technically, there's laws out there that says a husband and a wife could sue each other for sexual harassment under California Civil Code Section 51.9. Okay? This is not an area where you're going to see some politician out there running for office saying, hey, let's decrease the rights of those people who are accused of, or who are victims of sexual harassment. The political mood going on in this state in the United States is not to go through and give more rights to alleged sexual harassers. That's not going to happen. So what you're going to see is tougher and tighter laws, in my opinion, coming down about this topic. And you're seeing the damages going up higher and higher when people get sued for these things. Okay, if you go through and look at third-party sexual harassment, let me give you that example real quick. We've got a situation here where I'm over here telling a joke here to this person over here. Unbeknownst to me, somebody else is over here, and over here is my dirty joke. Is that sexual harassment by me towards that person? Everybody thinks yes, raise your hand. Everybody thinks no, raise your hand. It is sexual harassment. In that particular case, doesn't matter if I know she's there, or he's there, or whoever it is over there. Basically, I created a hostile work environment for that person. It doesn't matter what my intent is. I don't have a right to do that. Okay? Be aware of that. Be aware of what's going on in the workplace over there. Other examples that you can have regarding sexual harassment, there's a long list of things, but if you rank sexual harassment as far as the worst type of sexual harassment to the more mild sexual harassment, there's a case out of Illinois that says that leering, L-E-E-R-I-N-G, is a form of sexual harassment. I'll suggest to you that if leering is sexual harassment takes place in nearly every place of business, probably once or twice a day where they've got 30 or 40 more employees. The issue is not so much whether or not sexual harassment occurs, because it does happen, let's face it, throughout workplaces. The issue is what's the value. And many times, quite frankly, I'm not going to spend, if I'm a plaintiff's attorney, I'm not going to spend $100,000 or $200,000 on a leering sexual harassment case. I want one of those cases where there's physical touching going on. Those are the more valuable cases. And so attorneys screen these type of cases to see which type of case they really want to have out there. The bottom line is from FMC, they won't tolerate anything because they've got a zero tolerance level. And that's what's important to realize. And the reason, again, if you see your managers and supervisors clamping down on you and basically saying, hey, don't tell those jokes here in the workplace, it's because they've been told by me within the last couple of months they can lose their house because they let you do those kind of things. It kind of makes your sense of humor go away when you think about your children being in a pup tent because some clown's telling a dirty joke. So you want to be aware of those things out there. You want to be cautious about that, and that's really kind of what we're looking at. Page 6 of the outline. What we've got here is some liability. I've given you some citations for state and federal codes. At the bottom of the page is a copy of California Civil Code 51.9, which says that sexual harassment applies not only between employers and employees, it applies between landlords and tenants, doctors and patients, teachers and students, and basically any time there's a fiduciary relationship between the two. It's a pretty good argument there that somebody can get sued for sexual harassment. Page 7 talks about prevention of sexual harassment, gives some policies and procedures that you can exercise as an employer going through handling those matters. Page 8 talks about basically obligations that employers should have as far as how they handle such matters, and these are the guidelines that FMC is following as it relates to handling such situations over there. Besides what they have, again, what's most controlling from FMC is what their written policies and procedures are. Page 9 goes through and talks about updates on sexual harassment. And what you'll see on page 9, 10, 11, and 12 are sexual harassment cases. And these are some of the more recent sexual harassment cases which I'm providing to you to go through and review and give some consideration to. We've got 2 minutes. Got any questions or comments that you'd like to direct? Now's your chance to go through and get those freebie legal questions in. Yeah?
Kind of like what you said on the joke where the person hears a joke they're not supposed to. If you are in a, like, let's say in an office, and the door is mostly shut, and it's just between the two of you, because somebody walks by, that's sexual harassment?
If they hear it in the workplace. The law basically says it doesn't matter if it's intended or not. If people are making remarks in the workplace where anybody overhears it and it's foreseeable that they would have overheard such remarks in the workplace, you're responsible for it. Because basically, the workplace is not meant to be a place where you're telling a bunch of dirty jokes and making dirty remarks.
What if you're on lunch break?
If you're on lunch break, if it's on premises, there's still the same argument because many people here will not be on lunch break. And so what happens is, and quite frankly, there's another issue that comes up. We had in one case not too long ago where they had a common break room. And what they were doing was they had a TV up there and they were watching soap operas. I don't know if you've seen, I haven't watched soap operas in a long time, but quite frankly, some of the stuff on there is tougher than pornography that's going on out there. And so they had complaints about that. And in this particular case, it was a supervisor who loved this show. So what you had was a supervisor forcing basically the staff to go through and watch this soap opera during their lunch breaks. And the issue was that it's sexual harassment. And there was a pretty good argument there that there might be a real hostile work environment because of that. So you've got to be kind of aware of what's happening there in that regard. Other questions? Anything else?
I got it.
No.
Yes, sir.
So one of these were, the guy was intoxicated, he didn't know what he was doing. But for, let's say his attorney inside, if he can prove that he has a condition like he's an alcoholic, so it's a disease that he has and stuff like that, how would that have played in that?
Might help him with the Americans with Disabilities Act if he's trying to get discrimination based on that, but it's not going to help him for sexual harassment. The standard is, well, what the standard is, again, if he's somebody, for instance, where they've had cases like this, where they have somebody who's mentally retarded, and basically the issue comes up and says, did they engage in sexual harassment? And an objective standpoint, looking at that, did this person really intend for that to happen? Simply because somebody's mentally retarded doesn't mean they don't have sexual desires and wants and all that stuff. Simply because somebody's intoxicated, can't control themselves, doesn't mean they're not coming off objectively as causing the problems. So they look at those cases on a case-by-case basis to see what happened there. That's a good point, good question. Anything else? I'm 30 minutes, that's it. Thank you very much, appreciate it.
Thank you.